All right, good afternoon. Welcome to the House Environment Committee. This afternoon, we're going to talk about an amendment to S-124 with our legislative counsel, Michael Grady.
Good afternoon. This is Michael Grady with Legislative Counsel. Hopefully you are looking at a draft 2.1 S-124 with a May 16th date and a 9:59 a.m.
May
I'm
6th. Did you?
5/16.
Oh. So it was posted
You
previously?
sent it to me yesterday.
Did, but I drafted it last week.
Before I asked for it. Wait a
No, you asked for the instance by instance last week,
minute. How brilliant. Okay,
and
great. Sorry, interrupting. Go ahead.
So what does this do? Generally, you may remember in your discussion last week, this document, which were recommendations made by certain interested parties about changes to be made. What this proposal in front of you does is it implements recommendation 2, which would provide that when A&R is going to administer a Vermont pollutant discharge elimination system permit or program, that it shall be at least as stringent as the Federal Clean Water Act. And the rules that they adopt, revise, and amend would also be at least as stringent. And then there would be conforming changes to reference the fact that the Agency of Natural Resources has the ability to adopt their own Vermont pollutant discharge elimination system, CAFO rules. So most of the changes are those conforming changes. But then there is another provision you were discussing. It was recommendation 1 of the input from the interested parties about having an inspection schedule. There is no schedule in the amendment. There's just a report back from A&R about what that schedule should be, scope, frequency, cost, staffing, etc. And so that's generally what it does. Recommendation 2, at least as stringent as the Clean Water Act and conforming amendments, report from A&R on inspection. And then the clamp, as Rep. North called it last week, with regard to what the at least as stringent as will be complying with. It is the Clean Water Act and its enabling regulations as they existed on January 1, 2025 of this year. So that's generally what the bill does. The page 1, line 7, first instance of amendment. This is in an Agency of Agricultural portion of the Ag Water Quality section, where there is a reference to federal regulations for concentrated feeding operations. There is now going to also be a reference to the VIPTES CAFO rules. Very similar change. The next second instance of amendment, this is in the Agency of Ag's medium farm operation section, where it references the federal regulation for CAFOs. It will now also reference the VIPTES CAFO rules. And that change needed to be made twice in that 6 VSA 4858. Third instance of amendment, you're moving out of the Agency of Ag's authority. You're moving into A&R's authority. And this is in the definitions for the new subchapter on CAFOs. And where there is that reference on page 2, line 2, to the VIPTES CAFO rules adopted by the Secretary. Moving down, page 2, line 4, in the authority that you give the agency secretary, specifically of natural resources, underneath the CAFO subchapter, this is where you will see that language about how she can implement the Federal Clean Water Act to administer a BIPTES CAFO program that is at least as stringent as the Federal Clean Water Act and enabling rules. Similar change, page 2, line 9 through 11, make, adopt, revise, and amend rules as necessary to administer the BIPTES CAFO program that is at least as stringent as the Federal Clean Water Act enabling rules. And there should be an is before at least. The next change, there is no change in subdivision 3. I just needed to include it for the mechanics of the amendment. But there was a change in page 2, line 15, subdivision 4. It's that reference on line 16 to under the BIPTES CAFO rule. The fourth instance of amendment is in the community stakeholder group. This is no longer related to recommendation 2. This is recommendation 1. This is the inspection. The plan shall include a proposal of which AFOs.
Where is this? Where are we?
Page 3.
Page 3.
Okay, yep. Thank you.
This is a report from ANR, so it's not a mandate for inspection. It's a report, and they'll give you a plan to include a proposal which AFOs should be subject to inspection, including whether all large farm operations and medium farm operations must be inspected to determine if a CAFO permit is required. Proposed schedule of inspection of those AFOs subject to inspection, including frequency or events or threshold that would require inspection, and an estimate of the staffing or other resources that would be required to implement the proposed inspection plan. And then again, we're going back to the conforming amendments to recommendation 2. You're in 10 VSA 1259, which is a general discharge permit requirement in the water quality chapter, and it would reference the requirement for a CAFO by inserting basically the BIPTES CAFO rules. Same thing in 6th instance of amendment 10 VSA 1263, inserting the BIPTES CAFO rules where relevant. Same change in the 7th amendment and the stormwater discharge permit requirement. You'll see page 4, stormwater runoff from farms in compliance with ag practices adopted by the Secretary of Ag, not subject to the Federal Clean Water Act, its enabling regulations or the BIPTES CAFO rules. And then on page 4, this is the clamp. There was concern about whether when statute refers to the Clean Water Act or its rules, what that would mean if those rules or statutes were weakened at the federal level, and that you wanted to maintain the current strength or current status of the state program when referencing the Federal Clean Water Act. So that's what this section does. There is language in both Title 10 and Title 6 that says when the Clean Water Act is referenced, it's as amended. So the first thing I need to do is, notwithstanding statements to the contrary in 6 VSA Chapter 215 or 10 VSA Chapter 14. So those things, those statements where it's the Clean Water Act as amended, when the following are referenced in 6 VSA Chapter 215 or 10 VSA Chapter 47, the text of each shall be applied and interpreted as each public law, statute, or regulation existed on January 1, 2025, regardless of any subsequent amendment, repeal, or other substantive change. Page 4, line 15, that reference to public law number 92-500, that is actually what the Clean Water Act is. It's not technically the Clean Water Act, it's the Federal Water Pollution Control Act, but nobody calls it that. But it's referenced, 92-500 is referenced a couple of times in Title 10 and Title 6, so has to be referenced. The Federal Clean Water Act is also referenced in both titles, and so that's listed. The federal laws or regulations related to the Clean Water Act are also listed. And then the enabling regulations of the Federal Clean Water Act, including citations to the CFR, also included. And then there are references in both Title 10 and Title 6 to the federal regulations for CAFOs and the federal NIPDES regulations or federal NIPDES regulations. Both of those last two have to be referenced because they dictate the requirements for the Vermont VIPTES CAFO program. There are mandatory minimums in both of those regulations. And then everything would be repealed, all of that subsection A, that clamp would be repealed on January 31st, 2029. Now, the January 31st, 2029 date, that is really something that I drew from other language I have drafted relating, remember the good cause clause discussion we had about the Trump administrative order, executive order dictating that agencies repeal their rules. Well, that expires January 31st, 2029. And so that's why I use that date. But I think it was Rep. Chapin made the point that that's not a lot of time for you to respond legislatively in 2029 if you want to underneath this language. So if you want to push this date out, I think that makes sense for from a legislative reaction point of view.
Yeah, I think that would make sense. A couple of months anyway, maybe 2.5, 3 even. So January, February, March, April 1st.
April 1st, is that what I heard?
Sure. Keep seeing April 1st dates this year on the bills. Yes.
Okay.
Your question?
I do have a question.
Representative Nora.
I thought last Thursday, we all agreed on the complies with verbiage rather than the as stringent as or whatever. Strict as.
At least as stringent as opposed to. Was.
I thought we all agreed to complies with.
We talked about complies with, I don't know that we all agreed to it, and I guess, I'm the one that requested the language. I guess I feel like, we need to give A&R the tools they need to do this job that hasn't been getting done, and this is one of the ways to do that. And
So that agreement we had Thursday has been overridden, so.
sure, we had an agreement. I think we had I mean, I didn't hear an agreement, I guess. A few of us talked about it, and then we had a vote on something else, and then we adjourned. So we were in the middle of a debate about language changes that got derailed, and then we didn't come back. Representative Sakowicz.
Yeah, I think that's exactly what happened is I think we were moving perhaps towards that and then we got pushed off in a different direction before we had a chance to finish that conversation. But thinking about it some more, I was really wondering whether there's a practical difference between using those words or using the language that's in the bill. If there really would be a substantive difference. Certainly, it sounds good to me either way, and I'm not sure. I'm having a hard time putting my finger on how it would play out differently one way or the other.
Representative Logan.
I feel like it would be helpful to have an example of something that A&R might do that would be more stringent than the Clean Water Act. or that would fit into this category of action that we want them to be able to take?
I guess for me, ANR is actually the bottom line for water quality in the state of Vermont. And we need to give them the tools they need to do their job, which they have not been doing. And we need them to do it. This is what this is.
There is an easy example. Right now, the federal EPA CAFO rules allow for an exception for the 24-hour, 25-year flood event. Whereas state rules under ag don't allow for that right now. It's possible that ANR would continue with the current state standard that doesn't allow for the 24-hour, 25-year rain event. So that would be more stringent than the feds.
And
Sounds
Um,
necessary.
And could you make that same choice? Whether we use the word complies versus as stringent as.
So that
As?
being more stringent would comply with the federal, but it would be more than. So I do think if you use comply to really focus on what you want to do, you would say at a minimum complies with the Federal Clean Water Act. And then you really are the same as stringent as. Because without that as a minimum, you're going to have an argument that it can't deviate from the Clean Water Act. And I think that was a large part of the discussion last week.
Representative Chapin.
I think just from my perspective, what's happened over the last few days since we had this conversation, which I actually wasn't here for the complies with conversation. I was out for a period of time during that conversation and came back. It's just hearing again from advocates how they did not have a chance to present any of their amendment requests on the Senate side on this bill. And that of the 8 requests, we're only really moving forward with a few of them. And this language came from lawyers that agreed that as stringent as was best for clean water protections in Vermont. And we had never heard any real reasons not to use it from our agency partners in their testimony. So just sort of reflecting back on testimony from both advocates and agencies, the as stringent as seems to be, for some of us, the appropriate and recommended language to move forward.
Representative Logan.
Yeah, I know that conversation had after committee last week, also included more explanation for the concern that, ANR would then have the freedom to make up, like an entirely different set of regulations that would compete with and or override RAPs, for example. So I think that was the concern that had been expressed. But at the same time, our own state water quality standards already exceed federal water quality standards. So we don't want ANR to be limited by federal water quality standards either. So we want clarity in how this is going to be implemented without tying ANR's hands.
All right, further questions? Okay, thank you, Michael. We will shift gears to.
So I will come back tomorrow with the tweak.
Great, thank you. Basically, we're shifting gears to H319, which is not in our possession, so we've been asked not to put it on our agenda. It is, we're going to look at changes from the Senate because I would like us to have time to understand the changes that have been made to the bill in time for us to deliberate and make a decision when we do get the bill back in the House. Michael has provided us with section by section. Oh, did you do a side by side or a section by section?
I did a side by side. I might not have sent it.
We do have a nice section by section, but let's see. Really.
And are we supposed to open?
It's a side by side. I have it. Let me send it to everybody and Monica.
I am sorry. I bet what happened is I teed up the email and something distracted me and I never sent it, but I can be, I know what the differences are, and so I can walk you through them if you would like.
Well, I'm sending it to everyone right now. I have the side by side.
Oh, you do?
Yep, you sent it to me, so I'm just sending it to everybody now.
Okay.
And so while we're getting this up to speed, can you update us on, you were just in Senate Finance, so where is the bill currently located and what's its path?
They were taking testimony from interested parties. Pete Laflamme, Matt Chapman was there. Rygate had already testified. I think they are, my takeaway was that they were just gonna pass it as is.
So probably they Senate Finance did vote out H 319 unanimously.
Oh, great, they sent it right this afternoon.
I believe it has to make a stop at appropriations for some
Yes, it
reason.
does. It has the contingent funding in it for the SALT program,
Okay,
and so that'll send it there.
great. All right, does everyone have the side by side available to them? Take that as a yes. Let's start working. You have it, Michael?
Maybe just send us a 319 side by side.
You have it, Michael?
I have a hard copy. I'm just trying to see if I have the electronic copy.
To you, right? 319. It was you. Okay. Yeah. Right. Attached. Okay. All right, let's go.
Okay. Do you just want changes?
Do folks need high level? Maybe we could just each section remind us. We don't need to walk through every section, but the sections that just remind us what they do, because it's been a while.
First section, unchanged, it's the battery EPR report. You're having stewardship organization report on those difficult to recycle batteries, and they're gonna get an extra year to do that. Section 2, unchanged. That relates to the inspection standard for category 1 underground storage tanks. It's moving away from a visible standard to a more predictable agency designated standard. Section 3, household hazardous waste EPR program. This is only changing on page 3 in the definitions of what is not a covered household hazardous product. Architectural paint is being expanded to include paint products. And that is the only change in the household hazardous waste products EPR program. So on page 3 of the side by side.
This doesn't have page numbers, what I'm looking at.
At the top right hand corner, I see a 3 on the Word. Did you open it in Word?
You have to open it in Word.
Oh,
Thank you.
Representative Chapin.
So is there a definition of paint products?
Definition of paint products is as the term is defined in 6672. And it is architectural coatings, aerosol coatings, non-industrial coatings, and shoot.
That's okay. It was
There's
very
a definition.
specific couple of items.
And this change is necessary because of at
Right.
the last minute, we were asked to make a change. We didn't have time to take testimony. We sent it to the Senate. They worked on it. And so,
Right, but remember, there was the question of whether or not these new types of paint products under the architectural paint program should be covered under covered household hazardous products or should be covered under paint. They're going to be covered under the paint EPR program and not under covered household hazardous products. And that is why you're clarifying the exception here from the covered household hazardous products program. Should I move on? You can skip to page 20 because nothing else changes in the covered household hazardous products program. And 20 is where the paint program is at. As the chair just reflected on, noted that there was not enough time or to add this, or still some things that need to be worked out for inclusion of paint product stewardship program. And 319 as it passed your committee. Most of these changes are the conforming change of changing architectural paint to paint product. You will see the definitions of those new products on page 21 and going forward. Coating related product. It's a product used as a paint additive, paint thinner, colorant, remover, sealant, surface preparation, surface adhesive. Then on page 23, the non-industrial coating, arts and crafts paint, automotive refinish paint, driveway, etc. And then the definition of paint product, which brings all of them underneath one umbrella: architectural paint, aerosol coatings, coating related products, and non-industrial coatings. I will say, I think the agency and Paint Care did a good job of developing these definitions. But just from being in Senate Finance and just being like, well, where's tung oil? I don't know where tung oil is going to be. So the agency is going to have to make some determinations on some of these products of what categories they fall under and whether they're covered by this program or not. So again, good definitions, but somebody's going to come up with some product that isn't specifically referenced. So moving on in the paint changes. Do you want me to work through the mechanics of the program? I mean, the program's not really changing. It's just the scope. The key change is related to the paint assessment, which first is referenced on page 33. No, it's page 32 of the side-by-side. So
well, this other language is, oh, I see. It's just paint products is being added in here.
paint, right. Architectural paint being changed to paint product multiple times throughout. The name of the program is changing from the paint stewardship program to the paint product stewardship program. So mainly just conforming changes to existing law. There is a change on page 28 related to the payment of municipalities and how all of their costs for the collection and end of life management of aerosols, coating related products, and non-industrial coatings will be covered, because that was their big concern. that these products, which have kind of been something that they've had to incorporate into their household hazardous waste products program, is going to be covered by one of the two EPR programs. And so they wanted that clearly established. Paint is the one EPR program where there is a fee or an assessment charged to the consumer at the time of purchase to pay for the program. And currently, under current law, that fee, that assessment is developed by the stewardship organization, basically telling A&R what its costs are and recommending what the assessment should be on architectural paint. And then A&R approving that proposed fee/assessment. Well, that's generally not how you do fees in Vermont. Fees historically, traditionally have been set by the legislature. And that's because the Constitution says all revenue provisions have to originate with the House or the legislature. So what the bill does on page 32 is it strikes this current provision where the stewardship organization and A&R are setting the fee on paint, architectural paint, and instead there's a new section of law on page 36 going on to page 37, where it says that the paint stewardship assessment is intended to sustain the program and cover the costs of the program. But then, and that the stewardship organization can propose what it is, but then you set what that fee is in statute. And you set it first on page 37 for architectural paint, which are, these are the current fees. You're not changing the current fee. There's no additional cost that a person purchasing architectural paint will pay. But when they originally came forward with the language, there was this kind of range for the paint products, like they didn't really know what it was going to be, etc. And there was discomfort about having kind of this unknown fee or giving them discretion to set what the fee was going to be within that range for each of the types of products. So instead, on page 37, section 11, there's, and going on to page 38, there's a report back on or before December 15, 2025, A&R shall submit to you a report recommending a paint consumer fee or fees to be charged for paint products that are not architectural paint. That report comes back December 15, 2025. The expansion of the program to paint products is July of 2026. So you will have 6.5 months to set what the fee is going to be for paint products.
Representative Bartholomew.
On the very bottom of page 36, it says the paint product stewardship program shall propose new stewardship assessments that are sufficient. Proposed to whom?
To it really is going to be proposed to you, the General Assembly. Because now that it's set in statute, they're going to have to propose it to you.
Okay, right.
So moving on from there, the next sections 12 through 20, or maybe it's 13.
Before we move on, are we done with how the paint?
Yeah.
Yeah, so I just want to give, I think, and just correct me if I'm wrong, folks in the room, but we were asked to make this change by the manufacturers who didn't really want to participate in the household hazardous waste upcoming EPR. Is that fair to say? They already have this program going. They could fold these products into it. And then the Senate took testimony. We should probably look and see who they took testimony from, but I suspect they may have taken testimony from the two of you in this room. So I don't know if you want to just take a second to briefly let us know, does A&R support this, good with this?
So for the record, Matt Chapman, Waste Management Prevention Division of DEC, we're supportive of the language as it came out. So I think it accomplishes, so basically the Swimmies and the paint manufacturers came together and addressed the collection concerns, which I think was the main hangout with this committee. Both when it came in to this committee, and it addresses collection costs for paint related products, not architectural, but everything else in the paint program that satisfied the Swimmies. And our supports the way the fees are going to be set. We wanted to get out of the business of setting fees. It wasn't really something we do. So I think this is it's a good approach. Paint Care is a very effective program. And we, generally speaking, support it.
Allison, do you want to speak?
Sure. Allison Crowley for the American Coatings Association. Paint Care is a nonprofit that we set up to implement stewardship organization. I agree with everything that Matt said. We too are very pleased with the outcome of this and the discussions that we have with the Swimmies and the agencies and all the legislative hearings that we had, and we're hoping that we can get this through this session. And I want to thank everybody that we are working really hard with, including Michael with his multiple drafts.
Okay, great. Thank you both.
So moving out of paint, you come to, on page 39, section 13 of the Senate proposal. These are unchanged from your proposal. These are the amendments to Act 121 from last year about river corridor planning, flood hazard implementation, wetlands, dam safety, all those programs where the agency asks for generally a year extension. Sometimes it's a little bit longer, sometimes it's a little bit shorter. But sections 13 through 20 are unchanged otherwise. So that brings you to section 21 of the Senate proposal. You might remember in your as passed of 319, the agency came in and asked that the climate resilience strategy not be required to be adopted by rule, because they had already been working on it before the Climate Superfund Act, and they are going to be finished with it by September, and they don't want to have to go through rulemaking. So that remains unchanged. And so the language on page 47 and going on to page 48 is unchanged. It does what you did with the climate implementation strategy, including on page 49 in that directive in section 20 of your bill and 22 of their proposal, that because they're not going to rulemaking, you don't need rulemaking dates for them to meet in section 3 sub A. But the Agency of Natural Resources also asked that there be a delay in the rulemaking dates for the administrative rules for the Climate Superfund program. There are rules that require, like, when do you submit, when the agency submits the cost recovery payment, how a potentially responsible party responds, whether they have due process. All of those administrative rules, they're asking for an additional year in order to adopt those rules.
And the Senate, who did the Senate hear from on that?
They heard from Billy Coster, I believe.
Yeah.
And then they also asked for a change to the definition of covered greenhouse gas emissions. They want to clarify that the emissions It's not about measuring the total quantity of greenhouse gases released into the atmosphere during the cover period. It's going to be about measuring the equivalent resulting from the use of fossil fuels extracted or refined by an entity during the cover period. And this makes Vermont's law or Vermont's definition of covered greenhouse gas emissions consistent with New York's law. So for purposes of consistency with the two state, with New York, this was proposed as well. And then you have conforming changes in the definition of responsible party because covered greenhouse gas emissions clarifies what it applies to during the covered period. You don't need to reference the covered period. Similarly, in the determination of the cost recovery demand, you don't need to refer to the emission of covered greenhouse gases during the covered period because the definition of covered greenhouse gas emissions now addresses that. And on page 51, section 25 of the Senate proposal, the state treasurer has added an extra year in order to provide you with the assessment of the cost to the state of Vermont and its residents of covered greenhouse gas emissions. Moving on from there. Section 26. This is that good cause clause language for A&R when there's a federal reference to something that's amended, repealed, etc. It's going to continue in effect until January 31st, 2029. Page 52, section 27 of the Senate proposal. This is the commercial salt applicator language. It is largely the same as what you looked at in H86 with the affirmative defense language in it instead of the limitation on liability.
We need a primer on that.
Okay. I was hoping to escape that. So first, what that language does is in section 27, it clarifies that the purpose of these sections is to establish the accepted standards of care for the application of salt and salt alternatives in an effective and efficient manner that provides safe conditions for pedestrian and motor vehicles while also reducing the impacts of salt and alternatives on the quality of the waters of the state. And that is to say that it is to set the standards for salt application. For ANR to adopt the BMPs by rule have not changed. The substance of the BMPs has not changed. It's the same language that you were looking at in H86. The criteria that they keep records has not changed. The master applicator language has not changed. So all of that is unchanged. Where you see the change is on page 57 in the new section 1353. In H86, as it was discussed in your committee, if the commercial applicator was certified for 2 years, they had liability protection against a claim for negligence if that negligence of the damages were based solely on snow or ice and the removal of that snow or ice was due to them following the best management practices. You heard concerns and judiciary heard concerns from interested parties that prevented plaintiffs who had damages, who needed a remedy from seeking a remedy because it was a wall to the plaintiff from entering court. So what this does is it shifts from the plaintiff to the defendant, to the commercial salt applicator, they have an affirmative defense. And what is an affirmative defense? It doesn't prevent a plaintiff from bringing a cause of action for damages, but it provides that if certain criteria are met, that the defendant shall not be liable, even if they engaged in the activity that caused the damage. And that's what this does. It says the plaintiff can bring their negligence claim that they were hurt due to the commercial salt applicators, failures, etc. But the commercial salt applicator now says, my affirmative defense is I'm a certified applicator. I was applying according to the BMPs, and your harm was caused by the snow or the ice, which was there because I was complying with the BMPs. Plaintiff still says, but you were grossly negligent or reckless. And then if they show that, then the commercial applicator doesn't have an affirmative defense. Does everybody understand?
Is there going to be a quiz? Because Representative Austin.
I understand, but there must be specific criteria that they argue. I don't need to know what it is, but I'm assuming there's very.
It's the best management practices,
Right.
which are going to be adopted by rule.
Yeah.
All the interested parties will have an opportunity to participate in that rulemaking to set what those best management practices are. And remember, to set the standards for what commercial salt application is going to be. The purpose of the program is to do that. And so if a plaintiff is not, the plaintiff with the need for a remedy still has a remedy. They can bring their action. The standard of care of showing that they met the standard of care is on the applicator. But if they meet those criteria, then they're free of liability.
So I mean, I guess it's hard to follow exactly what the difference is. So my understanding of what the difference was going to be was that sort of burden of proof was shifted. Is that accurate?
Yes.
So the burden of proof is now on,
It's on the commercial applicator.
and before, as Bill has passed the House, it would be on the plaintiff.
It would have been on the plaintiff to try to pierce that liability protection. Now it's on the commercial applicator, the defendant, to show that they qualify for that immunity. In a way, it's not a significant change from negligence as it exists today, right? Plaintiff is harmed by your failure of duty of care. They bring a claim. You say, no, I met the standard of the duty of care. You're saying for a commercial applicator, this is the duty of care, and all they need to show is this, and they're free. They're released from liability.
That's the carrot we're giving them.
The carrot.
Representative Bartholomew.
I'm sure when you started this, you said, but why did they change this?
Because there were interested parties who felt that plaintiffs who had a need for a remedy were being shut out of or having significantly reduced opportunity for a remedy. This allows that plaintiff in need of a remedy to seek that remedy, but it also provides the commercial applicator with protection if they are meeting the standard.
I think you tried to explain that before, but now that you've been through it, it makes more sense.
Well, salt storage is not changing. There's no requirement mandate to cover your salt storage or your salt and sand or your sand. There's still the report back from A&R on the inventory of it and where there might be issues. The municipal affirmative defense or the municipal liability protection is now being changed to an affirmative defense, just like the commercial salt applicator. I won't walk you through the same exact criteria because it's the same exact criteria. But the big one, Section 32, page 63. There isn't money in the big bill for this program. And so A&R does not have a responsibility to implement this program until they receive an appropriation from the general fund for implementation of the program.
That was an amendment from our appropriations committee. So we know that that was in our bill. It should have been in our bill as passed.
So it was not,
Didn't go to the floor.
it didn't, right, didn't actually. And it was limited to FY 2026 appropriations. Which if technically, if you didn't get it, then the whole thing would have died. And so the Senate changed it to any general fund appropriation for the program. So next year, the money can be provided and these sections can be implemented. They will go into the statutes as they exist, as they're drafted right now, but they will have a contingent effective date over each one of these sections. Says this will not be effective until, and Lexis is gonna love that. They're gonna love that.
Hopefully we get funding before they find it. Representative Chapin.
But there's nothing here that stops A&R from implementing this if they find funding within their own, in some other way. Like,
There is one thing that they are still required to do that the contingent funding doesn't, and that's the salt management report. That is not subject to contingent funding. They have to give you that report. And it's true, if they want to go further, they want to start developing the BMPs, they can do that. And then moving on, section 33 is the extension for what is technically the base load renewable power portfolio requirement, which is Brigate.
And you did not draft this, so you probably don't want to walk us through it.
Brigate? I am not the person to talk to about this line.
That's what I just said. Yeah. All right. I do know that our energy committee is going to be looking at that Rygate language. I also know that I think it would be helpful for us to just get an overview from folks asking for it. So we will try to get that scheduled for tomorrow, actually, in our morning slot. Questions on 319 changes that we've walked through so far?
Why is the,
Representative Nora? Yeah.
why are we adding this baseload renewable power portfolio section here? This is supposed to be environment related stuff.
Right, so it went to Senate Natural Resources, which also does energy. And so over there it's combined and, I mean, Rygate and any power generation facility that, burns Vermont wood ends up, kind of covering multiple jurisdictions. So that's Rygate. Wood for energy. So I would say it's not an inappropriate location for the language. The folks running it have come in requesting an extension to their deadline that is also linked to some changes to their plan. But we'll let them come speak to that. Them or their lobbyist. I know they're in the building today. I don't know if they'll be in the building tomorrow. All right, any further questions? Not seeing any. Thank you, Michael.